Well, welcome everybody, and I'm back for the last session of the Hague in regards to the International Court of Justice, what we call the ICJ, which is holding public hearings in the advisory proceedings. Today, the final ones left to do is Spain, Fiji, and Maldives. And I showed you one this afternoon that was just unbelievable. Pretty amazing. I think that's one of the strongest cases. I think that the Arab states did in regards to what's happening in Palestine and Israel. And however you try to understand what's going on, you can't really understand until you really listen to what these people are saying, and that it doesn't start from October. In regards to what's happening in Palestine, it started way back in 1967. Actually, prior to that, but 1967 was when the Israel was trying to take over the entirety of Palestine. So, how does this affect us? It affects us in the sense that we need to help the Palestinian people collectively self-determine, which is their right. It has been their right since the 1960s, and they were never given that right. So those are the same rights that we have, and there's nowhere at the international level in the law that it says that we cannot self-determine together as many times as we want. It's the people that are in charge of their governance, and nowhere does it say that the government has to have final say over the people. What they did in a false decolonization method, or false independence that they gave all the countries, is that the governments of the day, the politicians, wanted to make sure to control everybody, as well as making sure that the private corporations got what they wanted. So by placing the people on top of government with final decision making authority, for them that was, oh no, you can't do that, and we're not going to say anything. So we're just going to decolonize them the way we want. We're going to enforce representative democracy, and even proportional representation doesn't even give us true democracy. So representative democracy, however you slice it, if we the people don't have final decision making authority at the end of the day, we are not free. And we need to make sure that the Palestinians get exactly what we've designed here at the CPU, to make sure that the Palestinian people never go through what they've done, and never are never stuck with a government that can go rogue, and that will actually act more as a dictatorship than the government of the people. So voting in for your next politicians and your next government, from what we've seen throughout history, always served one purpose. All we do is they only give us the right to vote for our next dictators, but it's up to the people to stand up, support Palestine in being the one country who will actually have this immediately, and to be able to discuss this, and how they can retain veto power over the decisions their government make if they don't approve of it, and that's collectively. So nowhere does it say anywhere in the international under international law. It says that we're allowed to self-determine together. We are responsible for what happens with our natural resources and everything else. But you'll be able to get some of the arguments while watching these sessions. And that's why they're so important. Each one of them brings something a little different to the table. So it's important to listen to all of them and the arguments that they make. So we have all of those same rights here in Canada and everywhere else on the planet, because those are part of our international Bill of Rights, our law rights. And those actually supersede our national rights. And 1 second here. I'm just hearing something in the background there. But anyways, the point that I'm trying to make is that this is very, very, very important. It's history in the making, and hopefully we at the CPU will be able to get through to all of the lawyers and the justices, and who's going to be taking care of helping the Palestinian people decolonize, to insert our recommendations at not the ICJ, but at least for the Palestinian people, to make sure that they always keep final decision making authority above their government, no matter what. so that they have an avenue to go to in case their governments go rogue. And this will help ensure that there will be no corruption. It'll be harder for corruption to take place when the whole of the people are in charge. It's easier to corrupt 338, let's say, parliamentarians and all of the other levels of governance. But it's not that, it won't be that easy to try and coerce a whole population of people. So they'd be able to more control corruption. Corruption wouldn't be able to breathe as easily as it does the way it is now worldwide. And they would also be able to make sure that wars don't happen, because it's not the people that want to go to war. It's always the rogue governments, and it's always for the sake of the empires, or I should say, the elite corporations that want the natural resources in different areas. And natural resources is a huge, huge, huge reason why Israel has been doing what it has been doing in Palestine. So please stay tuned, watch this. First, I'm going to go to why you need to join the CPU and support it. I need to do some housekeeping, and then we will start the session with the International Court of Justice. Thank you. Okay, so here we go. I'll be right back.
Attention, Canadians. Feel disconnected from our current political system? Join the power shift to freedom movement by the Canadian People's Union and be part of a bold vision for Canada's future. It's time to shift the political power to its rightful owners, the Canadian citizens and Indigenous peoples of Canada. Dive into our history, understand the need for change, and embark on the quest for true democracy. Are you concerned about our nation's commitment to human rights and self-governance? The power shift to freedom aligns with vital treaties and international laws, enabling us to claim our rightful place as collective head of state. We advocate replacing our partocracy system with a true democracy to ensure your voice counts more than party interests. When our national collective civil and political rights are respected, your influence on policies will be direct and impactful. Join us on this noble struggle to make every Canadian and Indigenous peoples a meaningful participant in our future. People 15 years old and over can sign the Convention of Consent and unite for our rights in the Constitution. Ready to be part of this transformative movement? Visit thecpu.ca for more details. Embrace the change and shape our future.
Please be seated. The sitting is open. The court meets this afternoon to hear Spain, Fiji, and the Maldives on the question submitted to it by the United Nations General Assembly. As the delegations are aware, they must keep to the 30-minute speaking time. I shall now give the floor to the Representative of Spain, Ms. Andrea Gavela Lopez. You have the floor, Madam.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. Spain, pursuant to the invitation by the Court in accordance with Article 66 of its Statute, presented a written statement on the 25th of July 2023. The current oral intervention aims to complete that written statement and furnish the Court with some elements that, from the Spanish point of view, may be of help in discharging the request made by the General Assembly. Spain, in this oral intervention, will amply rely on the advisory opinion rendered on July 9, 2004, on the legal consequences of the construction of the wall in the occupied Palestinian territory. As it is of the view that most of the Court's arguments and replies to be found in this opinion are of paramount relevance and are also applicable to the present case, we are going to address the Court in two main blocks. In the first one, we will briefly analyse the jurisdiction of the Court and then examine the international law applicable to the case, affirming that Israel is bound by this law. In the second one, we will elaborate on the particular issue of international responsibility of states in case of serious breaches of international rules that protect the basic interests of the international community as a whole. This second part will be dealt by Professor Mr. Ripoll Carulla, Head of the International Legal Office, while the first part will be dealt by Mr. Emilio Pin, Deputy Head of that International Legal Office, to whom I kindly invite you to give the floor now. Thank you very much.
I thank Mr. Lopez. I now give the floor to Mr. Emilio Pin. You have the floor, sir.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. The competence of the Court to give the advisory opinion requested by General Assembly in its Resolution 77/247 is based on Article 65, paragraph 1 of its Statute. The General Assembly, which seeks the advisory opinion, is authorized to do so by Article 96, paragraph 1 of the Charter. The questions are directed to the legal consequences arising from a given factual situation, considering international law. It is indeed a question of legal character. Therefore, Spain is of the view that the Court has jurisdiction to give the advisory opinion requested by Resolution 77/247 of the General Assembly. The lack of consent to the Court's contentious jurisdiction by an interested state has no bearing on the Court's jurisdiction to give an advisory opinion. The goal of the request before the Court is to obtain from it an advisory opinion which the General Assembly deems of assistance to it for the proper exercise of its functions and responsibilities. Mr. President, distinguished members of the Court, both Israel and Palestine are under the obligation to observe the rules of international law. In the 1967 armed conflict, Israeli forces occupied all the territories that had constituted Palestine under the British mandate, including those known as the West Bank, located east of the Green Line. This occupation was immediately and unanimously condemned by Security Council Resolution 242, which underlined that, and I quote, all member states, in accepting the Charter of the United Nations, have undertaken to act in accordance with Article 2 of the Charter, end of quote. The principle of prohibition of the use of armed force is one of the fundamental principles of international law, and, as formulated in General Assembly Resolution 2625, is accompanied by the following corollary. I quote, no territorial acquisition resulting from the threat or use of force shall be recognized as legal, end of quote. The Court, which has on several occasions affirmed the importance of this principle, has not hesitated to apply this principle to the Israeli occupation of the Palestinian territories. In the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territories, the Court has recalled the principle of the inadmissibility of the acquisition of territory by war. The Court concluded, and I quote, "Under customary international law, they were thus occupied territories in which Israel had the status of an occupying power." End of quote. Finally, the Court added, I quote, "Subsequent developments in these territories have done nothing to alter this situation. All these territories, including East Jerusalem, remain occupied territories, and Israel has continued to have the status of an occupying power." End of quote. Although Israel finally withdrew its civilian and military presence from the Gaza Strip in 2005, it has maintained full control of its borders, coastline, and airspace ever since. Consequently, as the Security Council has affirmed, the Gaza Strip constitutes an integral part of the territory occupied in 1967. The Court concluded that Israel's settlement policies in the OPTs, the measures taken with regard to Jerusalem, and the construction of the wall, I quote, "have been established in violation of international law." End of quote. Not only because they are contrary to the Fourth Geneva Convention, but also because they prevent the exercise by the Palestinian people of their right to self-determination. In its construction, the Court points out that the wall, the temporary nature of which is open to doubt, is accompanied by a regulatory regime aimed at annexing the occupied territories. This aim constitutes a serious violation of the rules of international humanitarian law incumbent upon Israel as the occupying power, has the effect of violating the right to self-determination of the Palestinian people and the human rights of the inhabitants of these territories. These statements are also applicable to the Gaza Strip. Israel's withdrawal from Gaza in 2005 has not meant that the occupation of the territory came to an end, and Israel has retained effective control over the territory through its control of airspace, territorial sea, and external land boundaries. The extensive documentation submitted to this advisory procedure demonstrates that 20 years after the Court's opinion, Israel continues to implement its policies, prolonging the very serious violations of international law found by the Court. Mr. President, distinguished members of the Court, on 3rd October 1991, Israel ratified both the International Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, as well as the United Nations Convention on the Rights of the Child. As stated by the Court, the protection offered by Human Rights Convention does not cease in case of armed conflict. Regarding the territorial scope of those instruments, they are applicable in respect of acts executed by a state in the exercise of its jurisdiction outside its own territory. That is, that they apply both to territories over which a state party has sovereignty and to those over which that state exercises territorial jurisdiction. Those elements concur in this case. Therefore, Spain considers that those instruments are applicable within the OPTs. As stated by the Court in its advisory opinion of 2004, the territories occupied by Israel have been now, for over 50 years, subject to its territorial jurisdiction as the occupying power. In the exercise of the powers available to it on this basis, Israel is bound by the provisions of human rights law and, furthermore, it is under an obligation not to raise any obstacle to the exercise of such rights in those fields where competence has been transferred to Palestinian authorities. Having determined the applicability of human rights law within the occupied Palestinian territory, it is time to seek whether Israeli policies and practices referred in paragraph 18A of General Assembly Resolution 77/247 have violated those rules and therefore have infringed the human rights of Palestinians living in the territory occupied by Israel. Among those rights that are being violated are those of Articles 17, paragraph 1 and 12, paragraph 1 of the International Covenant on Civil and Political Rights. Also, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967 has underlined in her latest report to the Human Rights Council that Israeli forces often detain individuals without charge or trial in what has been denominated administrative detention. Administrative detention is permissible only under very strict circumstances and must always be carried out in line with the protection afforded under international law. Palestinians in the OPTs are subject to a system of jurisdictional fragmentation in the context of a structure of institutionalized discrimination. Israeli military courts enforce military law upon Palestinians, while Israeli courts apply Israeli civil law to Israelis, including settlers. Regarding the International Covenant on Economic, Social and Cultural Rights, there are several provisions affected by Israel's policies and practices in the OPTs. For example, the right to work, protection and assistance accorded to the family and to children and young persons, the right to an adequate standard of living, including adequate food, clothing and housing, and the right to be free from hunger, the right to health, and the right to education. Similar provisions can be found in Article 14, 16, 27 and 28 of the United Nations Convention on the Rights of the Child. State parties to the Convention on the Rights of the Child, according to its Article 2, shall respect and ensure the rights set forth in it to each child within their jurisdiction. Of particular concern are the detention, interrogation, prosecution and imprisonment of numerous Palestinian children by Israeli occupation forces, practice that is contrary to Article 37, paragraph B of that convention. Certain policies and practices of Israel in the OPTs impose restrictions on the freedom of movement of the inhabitants of the OPTs and deprive a significant number of Palestinians of their freedom to choose their residence, and have, as well, repercussions for agricultural production through the confiscation and destruction of agricultural assets. On the other hand, the population of the OPTs is experiencing increasing difficulties regarding access to health services, educational facilities, and sources of water, impeding the exercise by the persons concerned of the right to health, to education, to water, to sanitation, and to an adequate standard of living. All these difficulties and restrictions infringe a number of rights of Palestinians residing in the territory occupied by Israel, which cannot be justified neither by military exigencies nor by the requirements of national security or public order. Mr. President, distinguished members of the Court, the International Law Commission, in the report of its 73rd session, has referred to the basic rules of international humanitarian law as having the status of a peremptory norm of general international law, jus cogens, with the legal consequences that that status may entail. The provisions of the Hague Regulations, annexed to the Fourth Hague Convention of 1907, to which Israel is not a party, have become, nevertheless, part of customary international law. Particularly pertinent in the present case is Section 3 of those regulations, which concerns military authority over the territory of the hostile state. Furthermore, the Fourth Geneva Convention, to which Israel is a party, is applicable in any occupied territory in the event of an armed conflict, and, as the Court has assessed, it is applicable to the territories occupied by Israel since 1967, including East Jerusalem. Regarding Israeli settlements, Article 49, paragraph 6 of the Fourth Geneva Convention provides that, I quote, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies." End of quote. It prohibits also any measure taken by an occupying power in order to organize or encourage transfer of parts of its own population into the occupied territory. Since 1977, Israel has conducted a policy and developed practices involving the establishment of settlements in the OPTs, which are in contravention of the aforementioned Article 49, paragraph 6. Therefore, the Israeli settlements in the OPTs, including East Jerusalem, have no legal validity and constitute a flagrant violation of international law and a major obstacle to the achievement of the two-state solution, as stated repeatedly by relevant UN Security Council resolutions. The establishment of the Israeli settlements in the OPTs is tending to alter the demographic composition of that territory, contributing to demographic changes, all in contravention of Article 49, paragraph 6 of the Fourth Geneva Convention. The practice of demolitions results in the forcible transfer or forced eviction of Palestinians and impedes a de facto return of Palestinian families and communities to their original dwellings, all in contravention of international humanitarian law. Furthermore, in 2004, the Court considered that the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case it would be tantamount to a de facto annexation, as well as a contribution to further alterations of the demographic compositions of the OPTs. Articles 47, 49, 52, 53 and 59 of the Fourth Geneva Convention remain applicable to the OPTs and are to be taken into account in this case. Spain is of the view that neither Article 51 of the United Nations Charter nor the state of necessity have any relevance in this case in order to preclude the wrongfulness of those actions. Mr. President, let me now invite you to give the floor to Professor Santiago Ripoll, Head of the International Legal Office.
I thank Mr. Pinn, and I'll give the floor to Professor Ripoll. You have the floor, Professor.
Mr. President, distinguished members of the Court, what are the legal consequences arising from the repeated, permanent and aggravated non-compliance of core rules of international law? This is the question the General Assembly requested to the Court. When this question is examined from the perspective of the law of state responsibility, the importance of the advisory opinion becomes critical. Articles 40 and 41 of the 2001 draft articles on responsibility of states for internationally wrongful acts answer this question. According to these articles, a serious breach of an obligation established for the protection of the interest of the international community as a whole entails the legal consequences stipulated for all breaches of international law, and some particular consequences. Therefore, the responsible state is obliged to seize the wrongful act, to give, if appropriate, guarantees and assurances of non-repetition, and to make reparation. Moreover, the responsible state is bound to continue performance of the international obligation. On the other hand, failure to comply with international obligations gives also rise to the right for the injured state to seek redress or take countermeasures. However, it has been said, Article 41 states that besides these ordinary consequences, serious breaches of jus cogens rules gives rise to some additional particular consequences, which, generally speaking, imply certain obligations for all other states to respond to the wrongful act, namely, obligation to cooperate with and bring to an end the alleged violation, obligation not to recognise the legal situation, and obligation not to render aid or assistance in maintaining the situation. Mr. President, my intervention will focus on these particular obligations of all states, other than the injured state. In its 2004 advisory opinion on the war, the Court briefly referred to these additional consequences. 20 years later, with the worsening of the situation in the occupied Palestinian territories, the Court is called upon to set out in greater detail these obligations. Mr. President, distinguished members of the Court, the duty to cooperate to bring to an end remains the first obligation of the states, according to Article 41 of the draft articles. This obligation to cooperate shall be carried out by all states. In the Israeli-Palestinian conflict, cooperation among all states has been organised in the framework of the United Nations. Once again, 20 years after the advisory opinion on the wall was passed, it is an indisputable reality that the situation in Palestine has worsened and that resolutions of the Security Council and the General Assembly have repeatedly condemned the actions of the parties and repeatedly demanded the cessation of the violations of international law. However, such resolutions have failed to establish redress and sanction measures. Therefore, the reference of Article 41 to the action of all states becomes critical. In some way, paragraph 159 of the advisory opinion on the wall underlines this when this paragraph established that it is also for all states to take measures to end the breach. Moreover, in the comments to conclusion 19 of the draft conclusion on identification and legal consequences of peremptory norms of general international law, jus cogens, we can read that this statement suggests that over and above collective action, there is an obligation on individual states to make efforts to bring situations created by the breach to an end. In the current circumstances, maybe the Court could determine what such an obligation to cooperate might consist of in this case. In doing so, the Court may take into consideration the numerous resolutions of the Security Council and the General Assembly, especially those resolutions stating that states are obliged not to take measures that would imply changes in the status of the occupied territories, including East Jerusalem and the Gaza Strip. Corollary is clear. Establishing diplomatic missions in the Holy City is a serious threat to the stability of peace in the region and the world. Coming back to the cooperation of all the states within the bodies of the United Nations, the Court could determine whether the obligation of all states to cooperate to bring to an end any serious violations of parental norms entails the duty within the Security Council, in particular, entails the duty to not prevent, hinder, or delay collective action in favour of the peaceful resolution of the conflict. Mr. President, let me move on now to consider the two particular duties included in Article 41, paragraph 2 of the 2001 draft articles, namely the duty not to recognise the legal situation and the duty not to render aid or assistance in maintaining this situation. What situation? The last resolutions adopted by the Security Council and the General Assembly on the Israeli-Palestinian conflict update the scope of the current situation that should not be legally recognised. Certainly, Resolution 7488 of the General Assembly, the first one, including this formula, calls upon all states not to recognise and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, including those aimed at advancing annexation in the occupied Palestinian territory. Since these two obligations have been reiterated by the Court and other United Nations bodies in this, but also in other situations, they are to be considered as customary law, something that, by the way, the International Law Commission has already affirmed. Finally, let me, Mr. President, to refer briefly to paragraph 3 of Article 41 of the draft articles, which states that international law may recognise additional legal consequences deriving from the legal regime to which the primary rule that has been violated belongs. These particular obligations can be found either in the foundation of the legal regime in particular or Security Council resolutions. Article 47 and 146 of the Fourth Geneva Convention are good examples of obligations provided for in the foundational treatise of a concrete, a particular legal regime like international humanitarian law. While Article 47 establishes the inviolability of the rights of persons in occupied territories, Article 146 refers to the obligation of the states parties to the Convention to prosecute and condemn persons who commit or ordered to be committed any of the grave breaches of the Geneva Convention. As said, sometimes these obligations linked to a particular legal regime sometimes are specified by the Security Council itself. This is the case of Resolution 2334 of 2016, which requires the states to distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. Mr. President, distinguished members of the Court, Spain formulates these considerations within the framework of a consultative procedure, aware that the Court, guardian of international legality, can offer the United Nations arguments to adopt decisions to address the situation and, at the same time, contribute to the clarification and development of international legal order. Thank you very much.
I thank the delegation of Spain for its presentation. I invite the next participating delegation, Fiji, to address the court and call upon Mr. Filippo Tarakini to take the floor.
Mr. President and esteemed members of the International Court of Justice, it is my great honor to appear before you today on behalf of the Republic of Fiji. Mr. President, for many decades, Fiji has built a tradition of peacekeeping. Our commitment to world peace is unwavering, and we are resolute in our efforts to contribute to global stability. I have personally had the privilege of leading peacekeeping operations in the Middle East over a period of more than 20 years. Mr. President, members of the Court, Fiji supports all efforts to establish a comprehensive, just, and lasting peace for both Israelis and Palestinians. Efforts that recognize the right of Palestinian people to self-determination and the right of the Jewish state of Israel to exist as a sovereign state with secure borders. Efforts that emphasize the need for the parties to engage in constructive negotiations as envisaged by the Security Council and the General Assembly. Fiji affirms the important role of this court as the highest judicial organ of the United Nations in resolving disputes between states and assisting UN organs in their activities. In so doing, the Court must promote the purposes and principles of the United Nations Charter. According to Article 1 of the UN Charter, one of the main purposes of the United Nations is, and I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, end of quote. Fiji strongly believes that the only way to achieve truly sustainable peace between Israel and the Palestinian people, indeed between any neighbors, is through mutual respect. As reflected in our written statement, Fiji considers it essential to maintain and uphold the legal framework agreed between the parties and sanctioned by the Security Council to resolve the Israeli-Palestinian dispute. That framework is founded on the understanding that Jews and Arabs must coexist in a small piece of territory. This requires direct negotiations between the parties for an agreed outcome. Mr. President, members of the Court, the General Assembly has requested the Court to answer certain questions that focus on the legal consequences of the policies and practices of only one party to this dispute. To answer these questions, the Court would need to carry out an independent judicial assessment of both the law and the facts on virtually every aspect of the Israel-Palestine dispute, taking account of the relevant context. This is not an easy task. As Judge Higgins noted in her separate opinion in the Wall Advisory Opinion, and I quote, "The law, history, and politics of the Israel-Palestine dispute is immensely complex," end of quote. Further, context is usually important in legal determinations. In Fiji's view, this court has unfortunately been presented in these proceedings with a distinctly one-sided narrative. This fails to take account of the complexity of this dispute and misrepresents the legal, historical, and political context. In its written statement, Fiji has provided several reasons why the court should exercise its judicial discretion not to render an advisory opinion on the questions that have been posed by the General Assembly. First, the request is a legal maneuver to circumvent the existing internationally sanctioned and legally binding framework for resolution of the Israel-Palestine dispute. Second, to give an opinion in this case, and I quote, would have the effect of circumventing the principle that a state is not obliged to allow its disputes to be submitted to judicial settlement without its consent. End of quote. And third, due to the one-sided formulation of the questions posed in Resolution 77/247, the Court does not have before it the accurate and reliable information that it would need to render an opinion on the questions posed. Mr. President, members of the Court, in this oral presentation, I will address the first and third of these issues. I turn to the existing framework. In these proceedings, the Court has been asked to render an advisory opinion that may well mean, in effect, the immediate, unconditional, and total end to the occupation. That is, withdrawal of all Israeli military, civilians from the entirety of the West Bank, East Jerusalem, and Gaza. This withdrawal must not only be complete, but it must also be unconditional. In other words, Israel may not impose or require any limitations or conditions. This unconditionality is supposedly necessary in order that the Palestinian people have a sovereign state on such territory, which they assert is the only way to achieve justice and therefore peace. Fiji respectfully submits that this demand of a complete and unconditional withdrawal circumvents the peace process and the agreements that have been made in pursuit of that process. Mr. President, the fact is that from 1993, Israel and Palestine entered into the series of agreements known collectively as the Oslo Accords. The parties expressed the intention to, and I quote, put an end to decades of confrontation and to live in peaceful coexistence, mutual dignity and security, while recognizing their mutual legitimate and political rights. End of quote. To that end, they agreed on a wide range of interim measures pending the achievement of a final agreement through permanent status negotiations. Some of those interim measures include the Palestinian Authority was established. Powers and responsibilities were transferred from the Israeli military government and its civilian administration to the Palestinian Authority, while Israel continued to exercise powers and responsibilities not so transferred. Direct, free and general political elections were to be held by the Palestinians. The West Bank was divided into three areas, A, B and C. The Palestinians would obtain exclusive control over Area A. Area B would be under joint Israeli-Palestinian control, and Area C would be under exclusive Israeli control. Lastly, the parties would enter negotiations on the permanent status to resolve the remaining issues, which included settlements, borders, Jerusalem, and security. In addition, the Oslo Accords contain a specific dispute resolution mechanism and do not permit either party unilaterally to commence or ask others to commence external legal proceedings. Since 1993, an extensive set of arrangements have been put in place to operationalize the agreements. In 2003, the General Assembly endorsed the Oslo Accords, and the Security Council has, and I quote, endorsed the Quartet performance-based roadmap to a permanent two-state solution to the Israeli-Palestinian conflict, end of quote. This court itself confirmed the importance of the Oslo Accords and the roadmap in the Wall Advisory Opinion in 2004. According to the roadmap, and I again quote, a two-state solution to the Israeli-Palestinian conflict will only be achieved through an end to the violence and terrorism. When the Palestinian people have a leadership acting decisively against terror and willing and able to build a practicing democracy based on tolerance and liberty, and through Israel's readiness to do what is necessary for a democratic Palestinian state to be established, and a clear, unambiguous acceptance by both parties of the goal of a negotiated settlement. End of quote. The thrust of the Oslo Accords and the roadmap is mutual performance and good faith negotiation leading to a consensual outcome. The Oslo Accords are legally binding. Remarkably, the Palestinians do not refer to these agreements in their written statement, while less than 12 months ago, both Israel and the Palestinians reaffirmed their, and I quote again, unwavering commitment to all the previous agreements between them, and to address all outstanding issues through direct dialogue. End of quote. Mr. President, it is our submission that the request to this court to opine on questions that address the legal obligations of only one party to this dispute conflicts with the clear rights and obligations of both parties in the Oslo Accords and the roadmap, and which exclude recourse to this court. For this reason, Fiji respectfully submits that the court should exercise its discretion not to render an opinion on those questions. Mr. President, members of this honorable court, I now turn to the issue of legal and factual evidence. As stated, in Fiji's view, the court should decline to answer the questions posed. But were it to do so, it would need to gather and independently assess the probative value of evidence on issues raised within the established legal framework of the dispute. This court would have to decide, as it has previously explained, and I quote, whether it has before it sufficient information and evidence to enable it to arrive at a judicial conclusion upon any disputed questions of fact, the determination of which is necessary for it to give an opinion in conditions compatible with its judicial character. End of quote. In Fiji's view, the court cannot simply defer to the reports of United Nations bodies. In order to fulfill its judicial function, the court must reach its own independent findings of fact. Further, Fiji submits that due to the selective and one-sided formulations of the questions, the court does not have before it all the evidence it would need to exercise its judicial function. Mr. President and members of the esteemed members of the court, the point here is that the court is being asked to focus solely on the policies and practices of one of the parties to this dispute, to the exclusion of the policies and practices of the other. This is highly problematic. If the court would limit itself to consideration of the questions asked, it would be unable to consider the relevant broader context, and it will also not have before it sufficient information and evidence to enable it to arrive at a judicial conclusion upon questions of fact that are in dispute, all of which would be necessary to give an opinion compatible with its judicial character. We will illustrate this by looking briefly at three of the issues raised by the questions that have been posed to the court. And these are withdrawal and security, territorial sovereignty, and the right to self-determination. First, withdrawal and security. Palestine argues that the occupation is illegal, and the legal consequence is that Israel must withdraw from the occupied territories. As highlighted earlier, any assessment of the questions posed would require the court to consider the legal rights and obligations of both parties under the Oslo Accords. The Oslo Accords were built upon Security Council Resolution 242 and 338, which were adopted following the 1967 and 1973 Arab-Israeli wars. They recognized the legitimate security needs of Israel to prevent further attack. Resolution 242 and 338, and thus the Oslo Accords, do not oblige Israel to withdraw from all the territories. Further, Resolution 242 and 338 refer to peace being established by the application of two mutually dependent principles, and I quote, first, withdrawal of Israeli armed forces from the territories occupied in the recent conflict, and two, termination of all claims or states of belligerency and respect for and acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area, and their right to live in peace within secure and recognized boundaries, free from threats or acts of force. End of quote. By incorporating these resolutions into the Oslo Accords, the parties recognize that Israel's withdrawal and the creation of conditions providing security to Israel are interdependent. As Judge Higgins stated in the Wall Opinion, both, and I quote, Israel and Palestine need to move in parallel to secure the necessary conditions for Israel to withdraw from Arab-occupied territory and for Palestine to provide the conditions to allow Israel to feel secure in so doing. End of quote. In other words, if the court is to consider the legal consequences of the alleged Israeli refusal to withdraw from territory, it should also look at what Palestine must do to ensure Israel's security. Mr. President and members of this honorable court, the events of 7 October 2023 have shown us what could happen if there were a complete and unconditional withdrawal without the necessary arrangements in place to guarantee the security of Israel and its population. At the very least, the court would need to examine and evaluate evidence concerning the question whether the 1949 armistice lines are secure boundaries within the meaning of Resolution 242 and 338. This in turn would require examination of the threats facing Israel emanating from the occupied territories and the broader region. Second, territorial sovereignty. Mr. President and members of the court, the General Assembly's request speaks of Israel's, and I quote, prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, end of quote. This asks the court to presuppose that all the territories held during the Jordanian and Egyptian occupation within the 1949 armistice lines are Palestinian. That is, that they are sovereign territories of Palestine and thus not of Israel. A precise definition of the scope of territorial claims is important because, and I quote, territorial sovereignty is a fundamental principle of the international political and legal order. It serves to divide between nations the space upon which human activities are employed in order to assure them at all points the minimum of protection of which international law is the guardian. End of quote. In the context of the questions put to this court, territorial sovereignty is critical because without clarifying the respective claims of Israel and the Palestinians concerning the sovereign status of the territory, it would be impossible to answer the questions of territorial scope of the Palestinian self-determination claim or the occupation. Fiji notes that the question of territorial scope, both of the State of Israel and of the self-determination claim of the Palestinian people, is in dispute between the parties. And yet, the way the questions are drafted excludes the possibility of the court considering Israel's claims to the sovereignty over the territory and asks the court to assume, without further investigation, that these territories are somehow Palestinian. Furthermore, the court would need to assess whether the Palestinians have sovereignty, and if so, over which territory. This would include an examination, among other things, of the history of the Palestinian assertions of claims and of whether Palestinians make different assertions of sovereignty in different fora. Palestine asserts that the provisions in the mandate for Palestine concerning the establishment of a Jewish homeland as envisaged in the Balfour Declaration were illegitimate and in contravention of the Covenant of the League of Nations. It appears to claim that all the territory of Mandate Palestine, even including what is generally accepted to be the territory of the State of Israel, belongs to the Palestinian people. Mr. President, Israel asserts, and Fiji agrees, that the mandate for Palestine, including its provisions concerning the establishment of the Jewish homeland, such as the right of the Jewish people to live in and closely settle the land, was a binding instrument of international law. Israel also argues that the relevance of the rights conferred by the mandate for Palestine was affirmed in Article 80 of the UN Charter, the so-called Palestinian Clause. There is thus a dispute about territorial sovereignty. Fiji submits that this dispute cannot and should not be resolved through means of the requested advisory opinion for two reasons. The first reason is that the question of borders and therefore the scope of territorial sovereignty was expressly agreed to be resolved through the permanent status negotiations to which the parties have committed themselves in the Oslo Accord. For the reasons set out earlier, this precludes the matter being adjudicated via an advisory opinion procedure. The second reason is that, in any event, because of the way the questions to the court have been formulated, the court simply does not have before it sufficient information and evidence to enable it to arrive at a judicial conclusion on the disputed issue of the geographic limits of the territorial sovereignty of Palestine and Israel. I now turn to self-determination. The questions before the court ask it to assume that Israel is violating the right of the Palestinian people to self-determination. The question of self-determination raises the question of territorial scope. This raises the evidentiary concerns I have just expressed. Moreover, Fiji notes that the right to self-determination is a relative right. It should not involve changes to existing frontiers. In the context of Israel-Palestine, this means that the court would need to ascertain whether the Palestinians' exercise of their right to self-determination has infringed the territorial integrity, political inviolability, or legitimate security needs of the State of Israel. By asking the court to look only at the policies and practices of Israel, Resolution 77/247 shields from the court's purview the policies and practices of Palestine. The result in Fiji's submission is that the court simply does not have before it sufficient information concerning the policies and practices of Palestine, and thus is unable to make a judicial determination on whether, in exercise of their right to self-determination, Palestine has infringed the sovereignty of the State of Israel. Mr. President, esteemed members of the court, in conclusion, the relationship between Israel and the Palestinian people is legally, factually, and historically complex. There are no simple answers. But there are two parties who need to jointly find a solution, and they should be supported to do this. Using the advisory opinion procedure to prosecute the alleged violation of international law of one of the parties to the dispute while ignoring possible violations by the other, will not promote dialogue nor foster mutual respect. Rather, it is likely to undermine efforts towards peace that can be best settled through the recommitment of the parties to the processes established under the Oslo Accords. In our view, this is why the General Assembly was seriously divided on whether this question should be put to the Court for an advisory opinion. And it is also why this Honourable Court should refrain from giving one. Fiji respectfully submits that for all these reasons, the Court should exercise its judicial discretion to decline to provide an advisory opinion on the specific question put to it in the UN General Assembly Resolution 77/247. Mr. President, were the Court to decide to provide an advisory opinion, which Fiji submits it should not, the Court should be cautious to ensure the advisory opinion rendered does not circumvent the binding agreements between the parties, but encourages them to promote fruitful negotiations. Furthermore, the Court should ensure that it does not impose obligations and responsibilities on only one party while disregarding its legitimate concerns. Mr. President, members of this Honourable Court, this brings me to the end of Fiji's oral presentation, and I thank you.
I thank the delegation of Fiji for its presentation. I now call upon the delegation of the Maldives to address the Court and invite Her Excellency Ms. Shakir to take the floor.
Mr. President, members of the Court, I have the honor to appear before you on behalf of the Republic of Maldives, a state staunchly committed in upholding international law. Support for the Palestinian people, including their pursuit of an independent sovereign state of Palestine, has been a long-standing cornerstone of the Maldives' foreign policy and remains so under the government of President His Excellency Dr. Mohamed Muiz, who took office in November 2023. There are no compelling reasons not to exercise jurisdiction. To the contrary, the dire humanitarian crisis unfolding in Gaza reminds us all that this is a historic opportunity for the Court to pronounce its verdict on the grave injustices that have been long perpetrated against the Palestinian people. The Maldives' oral submissions today will come in two parts. Ms. Amy Sander will first address the Court on Israel's multiple serious violations of international law in the occupied Palestinian territory, focusing on its practices in relation to water resources. Following this, Dr. Naomi Hart will provide concise answers to the two questions which the General Assembly has requested that the Court answer. Before concluding, I would like to once again reiterate our firm belief that the only sustainable solution to the conflict is the establishment of a sovereign and independent state of Palestine based on the pre-1967 borders with East Jerusalem as its capital. Mr. President, members of the Court, I thank you for your attention and ask that you give the floor to Ms. Sanders.
I thank Her Excellency Ms. Shakir. I now give the floor to Ms. Amy Sander. You have the floor, Madam.
Mr. President, members of the Court, representing the final state appearing, I have the honour of identifying the main points addressed during the course of this hearing on the violations by Israel of international law. The Maldives provides this analysis with a focus on the issue of water resources. Why? Because of two streams of significance. First, the significance of water resources to the Palestinian people. In fact, it has been described as the most vital resource in the occupied Palestinian territory by Palestine. A tidal wave of suffering has been unleashed by Israeli policies and practices with respect to water resources, which are characterized by deprivation, denial, discrimination and destruction. deprivation of access to water. Many Palestinians in the Gaza Strip simply have, I use the court's own words, no access to potable water. Denial of enjoyment of those resources on a discriminatory basis. In the West Bank, where Israel has seized control of water resources, use of vital groundwaters is marred by grossly inequitable allocations between Israelis and Palestinians. Destruction of vital infrastructure, with Israel demolishing sanitation structures and pipelines. The second stream of significance is to the questions before the court. The issue of water resources flows through four key aspects of the unlawfulness of Israeli policies and practices on which the oral submissions have focused, and I address each aspect in turn. The first key aspect, the violation of the right of the Palestinian people to self-determination. The following points are crystal clear. First, the Palestinians are a distinct people with a right to self-determination, an inalienable norm of Jus Cogens. Second, Israel's conduct has violated different components of that right, notably the right to territorial integrity, the right not to be subjected to demographic manipulation within that territory by a foreign power, the right of the people to pursue its chosen economic, social and cultural development, and its right to exercise permanent sovereignty over its natural resources. And the critical importance of this well-established latter component, the Palestinian people's right to exercise permanent sovereignty over their natural resources, was recently stressed by the General Assembly in its resolution of December 2023. Such resources clearly include water. Israel's policies and practices with respect to water resources, the deprivation, denial on a discriminatory basis, and destruction, thus constitute one acutely serious and ongoing facet of the breach of the Palestinian people's right to self-determination, described by our UN body as one of the most fundamental conditions for survival. For a people, sufficient clean water is indispensable. Turning to the second key aspect, the policies and practices of Israel in the occupied Palestinian territory violate the prohibition of the acquisition of territory by force. This afternoon, we have heard some attempts to muddy the waters in this regard, so I will recall the points of crystal clarity. First, a corollary of the Jus Cogens prohibition of use of force is the prohibition of any acquisition of territory by threat or use of force, irrespective of international recognition of Palestine's borders. The applicability of this prohibition to the occupied Palestinian territory cannot be in doubt, as expressly recognised in resolutions of both the General Assembly and Security Council. Second, international law requires that occupation be temporary. Third, any purported exercise of the use of self-defence must be necessary and proportionate. Fourth, and flowing from the three previous points, an occupying power cannot acquire sovereignty over an occupied territory, including by annexation, irrespective of whether it claims to have acted in self-defence at any point during the occupation. Yet Israel has annexed all of the occupied Palestinian territory, whether through Israeli law or conduct manifesting a de facto annexation, creating a fait accompli. And there's no shortage of evidence on this reality, as emphasised by many UN bodies and demonstrated by the map recently shown by the Prime Minister of Israel before the General Assembly, referred to on the first day of this hearing. Israel's deprivation, denial on a discriminatory basis, and destruction with respect to water resources is one facet of this annexation. The scale and nature of Israel's conduct in this regard makes clear that it forms an integral element of Israel's establishment of control through coercive measures, reflecting its intention to appropriate that territory permanently. The occupation having, to quote the Special Rapporteur, burst through the restraints of temporariness long ago. Israel's settlement expansion is plainly another integral element of that annexation, with Palestinians reduced to inhabiting a fragmented archipelago of disparate patches of land. Of course, the different aspects of Israel's violations of international law are not watertight from one another. Such prolonged occupation, annexation, and settlement expansion also violate the right of self-determination to which I referred earlier, a right which cannot be exercised in the face of a foreign occupier purporting to appropriate territory for itself and thereby dispossess the Palestinian people. The third key aspect is that the policies and practices of Israel in the occupied Palestinian territory violate the law of occupation. The indisputable starting point is that, as an occupying power, Israel is bound to respect, throughout the occupied territory, its obligations under international humanitarian law, a regime designed to ensure the protection of the people under occupation. And the Maldives agrees that the continuing applicability of international humanitarian law is without prejudice to the unlawfulness of Israel's occupation. Now, many examples of international humanitarian law breaches have been cited before the court, including with respect to Israel's settlement policy as a breach of Article 49 of the Fourth Convention. Israel's policies and practices with respect to water resources constitute a cascade of further violations of the Fourth Geneva Convention and the 1907 Hague Regulations. Notably, Israel's conduct is a violation of the rules prohibiting destruction of property, which includes water and sanitation infrastructure, in circumstances where it is clearly not absolutely necessary for military operations. It's a violation of the prohibition on destruction or removal of objects essential for survival of the civilian population, with water installations and supplies obviously qualifying as such. It's a violation of the prohibition on pillage, as well as the rules of usufruct. It's also a violation of the obligation to ensure and maintain public health and hygiene in territory it occupies. And this goes to a point of grave practical concern. A raft of horrific diseases spring directly from the lack of clean water, with little children particularly vulnerable. The fourth and final key aspect is that Israel's policies and practices in the occupied territory are in violation of international human rights law, including the fundamental Jus Cogens prohibition of discrimination. The irrefutable starting point, this is that Israel bears a duty to secure respect for the applicable rules of international human rights law throughout the territory that it occupies. International human rights law encompasses the right to water. Notably, that right emanates from Articles 11 and 12 of the International Covenant on Economic, Social and Cultural Rights. As the General Assembly affirmed in 2016, the human rights to safe drinking water and sanitation as components of the right to an adequate standard of living are essential for the full enjoyment of the right to life and all human rights. Further, as a party to the Convention on the Rights of the Child, Israel has expressly undertaken to pursue full implementation of each child's rights to the enjoyment of the highest attainable standard of health, including through the provision of clean drinking water. Equally clearly, international human rights law prohibits discrimination, notably pursuant to the Convention on the Elimination of All Forms of Discrimination. Israel is obliged to prohibit and to eliminate racial discrimination in all its forms and to guarantee the right of everyone, without distinction as to race, colour, national or ethnic origin, to the enjoyment of rights, which include a right to water. Yet Israel's discriminatory policies and practices with respect to access to water have been well documented and condemned by a deluge of UN bodies, with the Committee on the Elimination of Racial Discrimination, I quote, appalled at the hematic character of the separation of two groups, Jewish communities in illegal settlements on the one hand, Palestinian populations on the other hand, who do not enjoy equal access to water resources. The impact on women and children is notably egregious, with the dearth of clean water an acute crisis for mothers trying to feed their babies. Israel's policies and practices relating to water are but one among many examples of systematic discrimination which have been detailed by other states in these proceedings. And the Maldives joins the plethora of other states in confirming before this court that the regime which Israel has established throughout the occupied territory constitutes apartheid, pursuant to the customary international law definition as reflected in Article 2 of the Apartheid Convention. Mr. President, members of the court, at a human level, Israel's policies and practices with regard to water resources are inexcusably intensifying the hardship being endured by the Palestinian people and exemplify the illegality which has characterized Israel's occupation. The final speech for the Maldives will address how the court should answer the questions posed by the General Assembly in light of Israel's breaches of international law. Mr. President, I thank you for your kind attention, and I invite you to call Dr. Hart to the bar.
I thank Ms. Sander. I now give the floor to Ms. Naomi Hart. You have the floor, madam.
Mr. President, members of the court, against the backdrop of Palestinians' extraordinary human suffering cast in vivid relief this past week, the court's function is to provide advice to the General Assembly on the two legal questions posed to it. It is my honour, on behalf of the Maldives and as the final speaker in these proceedings, to provide succinct, direct responses to those two questions. Question A asks the court to opine on the legal consequences of Israel's ongoing violation of the Palestinian people's right to self-determination, its prolonged occupation, settlement and annexation of the occupied Palestinian territory, and its discriminatory legislation and measures. The states appearing before you have been largely consistent on this question, and that is unsurprising because the relevant principles are well established in the customary international law rules on state responsibility and the court's jurisprudence. First, Israel is obliged to cease its continuing unlawful acts. This includes, of course, an obligation to terminate its occupation, just as South Africa was obliged to withdraw from Namibia, where its presence was illegal. The court there specifically stated that withdrawal must occur immediately. Here, the General Assembly has recently stressed the urgency of achieving without delay an end to the Israeli occupation. But that is not all. Israel must also cease the discrete unlawful practices which have characterised its occupation. For example, it must dismantle the discriminatory regime concerning water resources referred to in Ms. Sanders' speech. In precisely the same way as the court previously stated that Israel must dismantle both the wall and the associated legislative and regulatory regime which entrenched discrimination. Secondly, at the same time as terminating its unlawful acts, Israel must provide assurances that it will not repeat them. Thirdly, Israel is obliged to provide comprehensive reparations. Restitution is optimal as far as possible, but you heard from Palestine last Monday that no action by Israel now could ever restore the Palestinian people to the situation which would have existed without its violations. In that case, Israel's reparations must include compensation. And to the extent that compensation will not fully make good the harms caused, Israel must provide just satisfaction in other forms, such as acknowledging its breaches and providing formal apologies. Fourth, there are obligations on third states. States parties to the Fourth Geneva Convention must search for individuals accused of committing or ordering grave breaches of that instrument and including the rules of occupation, and prosecute or extradite them. Further consequences flow from the occupation's unlawful status, and I will deal with those in relation to the second question. In question B, the General Assembly asked the court how Israel's policies and practices in the occupied Palestinian territory affect the legal status of the occupation and what legal consequences arise for all states and the United Nations. Ms. Sander has addressed the many illegal aspects of Israel's occupation. Each and every one of Israel's unlawful acts engages its responsibility as a state. But what is it that determines the status of the occupation? The factors affecting status are those that go beyond illegality in the conduct of the arbitration and that make the occupation irremediable, meaning that the occupation is what the court described in the Namibia opinion as a situation which is maintained in violation of international law. In other words, it is those breaches of international law that cannot be cured within the occupation, but only by the occupation coming to an end, that render it unlawful as a matter of status. One such matter is the permanence of Israel's occupation, notably the fait accompli that this court warned about in its Wall opinion. Israel has sought to create irreversible facts on the ground. As Ms. Sander has highlighted, by installing itself as an interminable presence, Israel has violated the prohibition on acquisition of territory by force. The court need not decide whether Israel's occupation was unlawful ab initio. Its wrongfulness can be established even if one looks only at the fact of its prolonged continuation with no end in contemplation. The wrongful permanence of Israel's presence, that breach of a peremptory norm of international law, cannot be corrected for as long as Israel remains in the occupied territory at all. That is why it goes to the occupation's status. The same is true when it comes to Israel's breaches of the right to self-determination. For example, that right encompasses an entitlement to territorial integrity, whether or not the territory is within internationally recognised borders, contrary to what you have been told this afternoon. It is inherent in Israel's ongoing occupation that it dispossesses Palestinians of their territory and that it divides the territory. Recall the fragmented archipelago that Ms. Sander referred to. Israel's presence and the Palestinian people's right to territorial integrity are mutually exclusive. And again, this is determinative of the occupation's status. What are the legal consequences of this analysis? For Israel, they include those I have already addressed in relation to question A, starting with the duty immediately to terminate the occupation in its entirety. Given the occupation's unlawful status, Israel simply cannot achieve compliance with international law as long as it remains in occupation. As well, Israel's ongoing presence cannot produce any effects as a matter of international law, and in particular, cannot change the status of any occupied territory. However, as Ms. Sander has alluded to, it is not a consequence of the occupation's status that Israel can somehow escape obligations concerning the conduct of an occupation. To the contrary, pending its urgent withdrawal, Israel remains bound by rules of international humanitarian law. Those rules apply whenever an occupation exists in fact, lawful or not, and as the court has stated, regardless of the status of the occupied territories. The same is true of Israel's obligations under international human rights law. Those duties are engaged based on Israel's exercise of jurisdiction, again, a purely factual state of affairs. The conduct of third states and the United Nations is likely to be of critical practical importance in leading Israel to end its unlawful actions. The people of Palestine, like the people of Namibia half a century ago, should be able to look to the international community for assistance in realising their rights. In light of Israel's gross and systematic breaches of Jus Kogan's norms, third states bear certain negative duties articulated in the court's previous advisory opinions. They must not recognise the situation created by Israel's occupation as lawful, or lend that occupation any support or assistance. Accordingly, they must avoid acts which could imply such recognition, such as engaging in trade or any other forms of relationship with Israel, which may entrench its position. They also must not enter into or maintain treaty relations in which Israel purports to act on behalf of or concerning that territory, except treaties of a humanitarian character. Third states must not send diplomatic or special missions to Israel with a remit extending to the occupied territory, as if that territory was simply part of Israel. A third state which does not uphold these duties may encounter consequences in its own relations with other states. According to the court in Namibia, no state which enters into relations with South Africa concerning Namibia may expect the United Nations or its members to recognise the validity or effects of such relationship. The same applies here. Equally, third states bear certain positive duties, an obligation to cooperate, including through the United Nations, to complete Israel's extraction from the occupied territory, a duty to remove any impediments to the Palestinian people's exercise of the right to self-determination, and a duty to ensure Israel's compliance with international humanitarian law. As for the United Nations, all of its component parts, but especially the General Assembly and the Security Council, should consider what further action is required to bring to an end the illegal situation. In 2004, the court urged the United Nations, as a matter of urgent necessity, to redouble its efforts to bring the Israeli-Palestinian conflict to a speedy conclusion. That urgency has not abated. It has intensified. How the Court advises the General Assembly on this occasion will, it is to be hoped, help to illuminate the path forward for the entire United Nations system. Mr. President, distinguished members of the Court, that concludes the submissions of the Maldives.
I thank the delegation of the Maldives for its presentation. This presentation concludes the oral statements by all the participants who have expressed a wish to participate in the present oral proceedings. It also brings to a close the hearings on the request for advisory opinion submitted by the General Assembly of the United Nations regarding the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. I would like to convey the Court's thanks to all the delegations who have addressed it in the course of these 6 days, as well as to the participants in the written proceedings. I would also ask the representatives of all participants to remain at the disposal of the Court in case it should require any further information or explanations from them. The Court will now retire for deliberation. The Registrar will, in due course, inform all the participants and all members of the United Nations General Assembly of the date and time when the Court is to render its opinion. As the Court has no other business before it today, I declare this sitting closed.
Okay, I'm just going to shut that off here and we'll remove that. Okay. Oh, now, I hope that you kind of enjoyed that. It's really amazing how can I say, what they've been saying all along for self-determination is what we've known. And also, they reiterate how these are our human rights are all automatically embedded into all of our constitutions, and especially if the countries have all signed on to them. Okay, so Canada and the UK have signed on to all of the what we call the Bill of Rights, the International Bill of Rights, which includes our human rights plus all of the civil and political rights and also cultural rights. And everything else that Canada has signed is embedded into that. So it's just amazing that in Canada, the lawyers all seem to think that because Canada did not create a law for it specifically at the national level or provincial level, it doesn't count. And that's the furthest thing from the truth. It's the one thing that stops us from being able to connect with them properly. They don't even believe us. They've been so brainwashed into a system that has actually removed those aspects from allowing law teachers to teach this to new lawyers. And then now we're stuck with a bunch of lawyers who have become judges that were never educated in that aspect. So it's really, really, really frightening to see how deep we are in Canada into that corruption. So for us, the biggest shocker was, well, the law is the law, and Canada keeps saying that we follow the rule of law, and they have to follow the rule of law, but yet it's all BS. It's all double speak. It's all a lie. And now, finally, after so many years, like you'd wonder, 20 years ago, they told Israel that they had to undo the wall that Israel created, segregating Palestine. Well, the people, the Palestinians, and they, after 20 years, they still haven't listened. And that is the actions that the UK has been doing forever. And then they pretend that they're there, they're going to help, and they're going to sign all of these agreements, and they're going to honor everybody's rights and blah blah blah, and then they spit all over you. I actually, said that the countries need to wake up because Canada is spitting on you. All of those countries that have made those agreements and signed those together made those agreements. Now in Canada, because there's no laws for it, and then they didn't give us any rights. All they did in the charter was to give us rights, the minimum rights, the minimal of rights, okay? The very basics of them. But they inserted clauses in there that they can take them away from us whenever they want. That is not legal, okay, because of the international laws. Nobody debates it. With the lawyers don't debate this. And then they'll say, well, you need to wait for an occasion where you can debate it. If the government hasn't done anything, then you can't just go ahead and debate it, even if you find something wrong with it. So here I have a few questions from people. Allison says, so how can they overlook the WHO, the General Assembly, should be disbanded along with? No, because see, the thing is a lot of people, I had a woman a while ago make a statement saying, I thought the WHO was bad and that we need to walk away from that. People are creating propaganda without knowing the facts. So when you're looking at something and you want to educate yourself as to what's happening and who to believe and who not to believe and everything else, you have to kind of become an investigative journalist, okay? And you have to look at both sides of the issue before you even make a judgment on it. So when I started looking at the, not the WHO, but the United Nations actually, there's some good parts to it. Not all of the UN is corrupted. And if we didn't have the UN right now, we'd have zero rights. Since the pandemic started, we would have zero rights. They could have done much worse to us, much worse. And that's the whole basis of going into globalization, having our countries being run by private corporations for the government. That's what they call public-private partnerships, okay? And now those public-private partnerships, they have more voting rights than our own governments do. Because why? They say, well, the corporations need more voting power, so they will get 51% and up, 51%, at least 51%. And then the Canadian government keeps 49% or lower. So whenever the corporations need to go for a vote on any issue, the government will never win because it doesn't have enough voting rights. So when you're looking at the UN and then you look at the WHO, well, did anybody read what the WHO states? That the WHO cannot override our human rights. But everybody's yelling, oh, we need to walk away from the WHO. Yes, in the sense, the WHO needs to be penalized. But what everybody is forgetting is that there was so much pressure there, thank goodness, that the WHO had no choice but to write in the preamble that they cannot override our human rights, which is 470 pages. We have 470 pages of rights. And it says exactly, the different areas of rights that we have. But nobody pays attention to that. We cannot afford to leave the United Nations. If we leave the United Nations right now, these countries are fighting for us to keep our rights. and to finally do something about the U.S. These countries have, the U.S. has always stuck their noses everywhere, as well as the UK and France, because they have veto powers. So whatever the UN decides to do, they'll come back and cut everybody off at the knees under NATO. So NATO would have to go into Israel and kind of invade them and stop them from doing what they're doing and clean up the mess. But the US keeps vetoing it. And then France has that chance as well. And so does the UK. But the thing is when they themselves have been, the way that the international law works, when they all agree to something, even countries that have not agreed and did not sign on, the other countries are responsible. And this is what you hear over and over and over and over again in their speeches at the court, saying, hey, the court has the right to make a determination here. Don't listen to the US, don't listen to the UK, and don't listen to Israel or any other country that is saying, well, you can't interfere right now because Israel is claiming that they're trying to negotiate. Trying to negotiate and actually negotiating is two different things here. So you need to understand that now they need to stop it now. So the whole thing about this was all the other countries going after what the United States has said, what the UK has said, and Israel, and proving to the court that, yes, the court has a right to render a decision here, and we want it implemented. So even though the countries have voted against Israel already, they had to bring it to the court for an opinion. And then Israel and the UK, and then we'll say, well, it's just an opinion, so it's not binding. Yeah, it is. But it's binding once NATO acts. And if NATO isn't acting on this, there's a problem. But the problem is those veto right countries. So they need, if our countries, the UK and the United States, who has veto rights in France, should not have a say in any of this. They should lose their veto rights because France actually gave Israel a nuclear reactor. Canada has been sending out arms to Israel and money, as well as the United States, as well as the UK. So those countries should not be allowed their veto power during something that they've interfered with and committed those crimes as well. They've aided and abetted Israel. And that's why now what's going to happen is once I pray that the judges come out and say, yes, we're going, the war has to stop now. But the thing is the UK, the United States and France and the other countries, the G20, who want globalization, who want to destroy our rights because they're afraid of these three groups. So the whole point of this is about ignoring international law to destroy our rights. We are lucky that this many countries finally stood up. They've been standing up and voting, but then the voting doesn't go anywhere because of the veto power. Well, the veto power has to come into question. So my suggestion was, hey, isn't by law, if they've committed these crimes, and the job of all of the other countries who have signed is to report a country, even though a country has not signed on, is to report that country and to stop it. So Canada was obliged to stop Israel. Canada was not supposed to send military equipment to Israel or to support Israel financially while it was applying force to a peoples they had no business to do it to. Especially during the rights to, now that we had the rights of self-determination in 1960. And then they turn around in 1967 and be that cocky. The UK, officially declares Israel the keepers of the Palestinian people. The whole thing is sick. But the whole point is about ignoring the rule of law, ignoring all of the agreements that they've signed. Like, so what? We're going to do whatever we want. Like a bunch of little boys, little kids there, holding a tantrum. And then what are they going to do? Are they going to be so pissed off that they'll launch a nuclear war? The United States said that they're ready for a war against Russia at the beginning of 2025. Yesterday, I heard that one of the generals said, well, you could expect it maybe by September. Are we as citizens going to allow this to happen, to allow our governments to throw us into wars? It's up to us to stop it, because all those reparations you've heard about a while ago, if Canada gets sued, we're going to be paying through the nose. There's going to be sanctions placed against us. We're the ones who are going to be barred from, trading food with others, or getting medications or whatever that we need. This is serious. So are we as Canadian citizens and Indigenous peoples here in Canada going to put up with this government sending us into a war because it's kissing ass to everybody else? Excuse my language. But that's the sad reality. Are we going to allow our judges to still be corrupt like they have for the last 3 years? Because if the lawyers had listened to us and brought in the Syracuse principles and used that in court, and the Johannesburg principles, we would not be discussing this today in Canada. And we would eventually get our rights. Some of the lawyers, I've seen that some of the constitutional lawyers know exactly what I'm talking about, but yet say nothing and make the CPU look like a bunch of fools. So nobody wants to support the CPU. Why? Because the lawyers are saying, oh, well, we don't look at international law here in Canada. Well, excuse me, but by law, the only ones who can charge Canada is the other countries. The only ones who can imprison our government officials, the ones who have done all this stuff, right down to municipal mayors, is the international level right now, because we don't have those rights. So we better be listening. You want to see them in jail? Hope to hell that these guys win. And that Israel, the UK, France, and the United States will not start, and Germany is also involved in this, will not start sending bombs our way. Well, the other way, and then, to try to retaliate. Because now you've got Russia and China together trying to defend the countries that Israel is trying to take over for the United States. So the United States and the cabal are trying to use every other country. They're using the Ukrainian people, destroying them, destroying the Jewish people in Israel, the Israelis, and using them against the Palestinians to do their dirty work. Do we know where our famous virus came from? It started here in Canada, 2003. Why was everybody asymptomatic for SARS-CoV-2? Because we were all immune. You think it just started in 2020? Absolutely not. So it's time for people to wake up. Canada launched that sucker for who? The United States, Fauci, NIH, in bed with our Genome Canada. What did they end up stealing during 3 years? Everybody's DNA. What did they start creating at the international level? Huge DNA banks to try and figure out what makes every race tick. How many of you know that? All of our provinces participated in that. I've been screaming about it. Nobody listens. It's like, holy crap. They're destroying the human genome with the mRNA. That is illegal at the international level. Canada is not supposed to touch our genome by law. but they're doing it. Transhumanism? Absolutely not, unless it's for research purposes only in Canada. But now we all want to be trans, we want these operations and we want these treatments and hormones, change our DNA. And what the hell is wrong with humans today? All those things that Canada has allowed to transpire here is illegal at the international level. Why? Because it makes no common sense. And you can't get a small group of people, take a small percentage of people, and then force the rest of 90% of the population to abide by 10% for their rights, because, they have rights too. Yes, we all have rights. They have rights too, but they do not have the right to penalize 90% of the population for the sake of 10%. Give them their rights, but they need to also respect the rights of the other 90%. So why should 90% be penalized for 10%? I'll be damned if anybody tries to give me a surname. Okay? No way in hell. So I've got nothing against everybody's rights. We are all equals, all humans. You want to do something to your body? That's your problem. But don't expect the rest of the population to pay for it because, you have rights. How many people would need clefts, all kinds of stuff done to help them? Well, you can't have that done because that's cosmetics and the government is not going to pay for cosmetics. Well, what the hell is transhumanism? It's cosmetics. So we need to clean this mess up. And it's not about being angry with the people who want to change their sex or whatever. Hey, they have their rights. We all have rights, but we don't have the right to impose a right on everybody else. What did they say over the armistice? Do not mention God because you're going to insult the people who came into this country. Excuse me, because they don't have the same God. Well, hello. Name them all. Name them all. Everybody should be respected in what they choose to believe in. As long as everybody's good, it doesn't matter. I don't say, respect Satan. But, we need to draw the line. Everything is so insane today. It's not even funny. We need to get back to common sense. And common sense now, anybody who has common sense now has a superpower. Because most people lack it from where I'm standing. Where does it make common sense to inject stuff into allowing little kids to make decisions, 12-year-olds, life and death decisions by having something injected into them? Since when are we supposed to believe anything and take it for, as gospel? People make mistakes. So we need to make sure that everything we do is in respect of everybody else. And if we want rights that haven't been recognized yet, well, bring them up and then we can all discuss it. But don't impose in order to give one right to one and then knock down the other 90%. You're just going to create chaos. You're going to create exactly what they created now, which is mass psychosis and hate amongst people. So now we're sitting in our country where we can't even recognize it. And we've got fighting going on over Israel and Palestine, over trans and non-trans and gays and non-gays. And what the hell? We're all human beings. Everybody has the right to be loved and to be respected. As long as you're not trying to kill everybody off. And you're good in society and you're a good, decent person. Why should it matter to somebody else what you want to do with your body? But don't force them to pay for it. You want that? Find a way of doing it. I support you 100%. If that's what's going to make you feel good, if that's what's going to make you happy. But there's other things that come into play here. Make sure you're not making a mistake, because you can't turn it around. So I'm more worried about them and their sanity, and how the government is using them against everybody else to create chaos and to change humanity as we know it, the human genome. They're not supposed to touch our human genome. So if we lose our international law rights and we can't get them recognized in our country, we lose everything. If we don't support these countries who are trying to save our rights, we lose everything. If we don't support Julian Assange with this crazy, idiotic idea that the Trump government had to have the UK pick him up and extradite him to the US for a charge of 175-year prison. And then, they've got the CIA documents where Trump actually said, can we have him killed off? But, everybody loves Trump. He couldn't have said that. Check out the trial of Julian Assange. It actually came out in the trial with the papers, with the proof. Careful who you want to put in government. Trump is the one that allowed Israel to declare Jerusalem the capital of Israel. None of the presidents anywhere on this planet want to do that because they knew it was wrong. But twiddly-dee there. Yeah, he supported Israel, all right. And now, but Trump now is mad at Netanyahu. He already made his mistake, and he needs to own up to it. So, this is why I'm showing you why this is so important, because every different session from every different government that went and pleaded at that court last week, and that's why I re-showed it to you, every single one of them has one thing that they can't produce the same thing. They talk about the same thing, but there's a different law that covers different aspects. And every one of them has to do that. Okay, it's like being an intervener in court when something goes to court. So they would go and make their pleas in regards to why the International Court of Justice cannot listen to the UK, the United States, and Israel, and the others, the few others that were there, that they need to remember this is the law. So they were there to reiterate the law. And every time they reiterate the law, they reiterate exactly what we've been saying all along. We have the right to collective self-determination. There's only one thing they've left out. And this is why the CPU is so important to the international level, is that when peoples have the right to collective self-determination, decide what they're going to do with their natural resources, and yes, they need to have a government so there's no chaos, but nowhere does it say that the people are not above their government, nowhere does it say that we have to choose a government, then give all the power away to that government without any way out for us in case they're a rogue government. We need to ensure veto rights. We need to ensure that the government, before it does anything that affects us all, that they come to the people in a referendum to see if we're going to accept whatever laws they're going to make, or whatever agreements they're going to sign, or whatever decisions they make with our natural resources. They're supposed to work for us. So we need to be able to have a way of penalizing them if one of them is corrupted. But imagine if we support Palestine in their decolonization process, right to self-determination. Nowhere does it say that a country doesn't have the right to self-determine whenever the people together decide to do it. They actually say we don't need the approval of our government as long as the majority says yes. then the government has to abide by those rules. So we need to have assurances. So we need to make sure the CPUs, everything that we've built is about making sure that the people are protected always. So if we can help the Palestinians establish their governments, but make sure that they have safety nets, okay, where they can stop their government from acting, and then so that the kids coming up, the future generations will never have to do what we're trying to do now, what we're having to go through. So if you look at France, the first country to have the people removed from imperialism, and they were supposed to all have a say in what happens in governance, until they all got scared and handed the reins over to Napoleon. They all lost their rights. But France says, but we're going to give you, get so many signatures, and you could come to the court and make your plea, and then we'll see about what you want changed. United States think that they're free. They're the least free people on the planet with their constitution. Why? Because every time we vote, whether you're in the United States, Australia, Japan, here, we give away our rights to representatives for 4 years to do as they please with us, as they please with our natural resources. Why are we paying taxes? We were supposed to pay taxes only for a few years during, World War I, after to be able to survive. 100 years later, 2017, made it a 100-year anniversary for taxation. And then they'll tell you, some people will tell you, well, it says taxation is, that it's voluntary, so I don't want to pay my taxes, so why should I pay my taxes? Well, if you don't pay your taxes by law, you're going to go to jail. You can go to jail. Well, why is that when it says it's voluntary? Because you need 51% to say, yes, you're not allowed, you don't need to pay your taxes. We need the majority on every decision we make. That's what collective self-determination means. When the government says, oh, it had to protect the rest of Canadians against the convoy, they use the rest of the population against us every time they want to prove their point. But that's our power. And we need to do it together. We need to have more members than the political parties do to really allow the CPU to make an impact, to save our rights and to save our country, our natural resources, before we lose it all. We need to stop them from using, giving medications and things to people without fully knowing the side effects. Everything is not a one-size-fits-all. Every situation isn't good for everybody. So all of these things need to be analyzed properly and make sure that nobody tramples on anybody else's rights. We all have the right to love, to be loved, to be respected, and to respect in return. So right now, if the trans people want to be able to go into bathrooms, hey, every en route that I see, there's a family bathroom. You're welcome to go in there. Your rights aren't impeded upon. You have no business in the women's washroom, though, because sex is sex, male or female, end of story. You feel more female or you feel more male. You've got no business, if you're a female and you feel more male, you've got no business in a man's bathroom, because in order to honor you, you're putting everybody else, all the males going in there, frustrated. So you have no right to impose yourself on everybody else just for one person. So a small percentage of the population cannot impose itself on the rest of the population. But we have to come to an agreement to say, yes, okay, let's give you an extra bathroom. Okay. But don't go into little girls' bathrooms or boys' bathrooms. Show some respect. And you will get respect as well. Instead of people throwing all kinds of accusations. Why are we fighting over the trans issue when there's a solution? Very simple. And it's not the right of the teachers to impress that upon the children. Children have parents for a reason. And parents have an obligation. And it's not to use daycare or schools as your babysitters. Parents have a responsibility. And the courts have no business charging parents with, a danger to their children because they're telling them they're a little boy or a little girl, or little girls can't do this and little boys don't do that. And now a teacher makes a report. This child came in to us and said, well, my mommy said that little girls don't do that. So she called you a little girl. You don't know, you're not old enough yet to know if you're a girl or a boy. Now, how insane is that? I would fire every teacher. I've got grandkids. Okay? And we're watching. I pity anybody that has to teach my grandchildren and they don't watch what they're doing. Because international law matters, and you do not override the rights of the children. And you don't just say, well, it doesn't matter in Canada, because if we can have the support of the Canadian citizens, yeah, our governments will see that it matters. Our lawyers will see that it matters. The judges will see that it matters. And the bar will stop interfering in everybody's bloody lives and the public health. We have rights, people. 470 pages of them. And then we have another extra 180 pages of why those rights are there and what the courts can do and cannot do and the governments can't do and cannot do. They were the Syracuse principles and the Johannesburg principles were created for the very sake of making sure governments did not override their rights and penalize the people. They were created because governments were taking too much rights. They were overstepping their agreements. Now, these 57, these countries, well, the 7 applications that went in, I think there's 52 or 53 countries, and the rest are NGOs. But we need to, the trans people need to sit down and think clearly, and the rest of the population as well. We need to make sure that the teachers really think their positions, doctors and nurses and everybody else as well, because everything's insane. There's no more normal. And people aren't even thinking normally anymore because everybody's so afraid that, oh my God, you can't say this because you're going to insult a gay guy, or you're going to insult a lesbian, or you're going to insult some parents, or you're going to insult a child, because they have the right to make life and death decisions at the age of 12. But yet they can't drink till they're 18 or higher or older. And then let's let everybody smoke pot for free. Like smoke pot, it's all legal. And then everybody's too stoned to see what's going on. How are we supposed to save this country? When everybody's afraid to be branded. Oh my God, if you don't agree with this, and you're saying this, Nicole, you're going to be ostracized. Well, you know what? I don't give a damn. Take me to court. Prove that I'm wrong. Try to prove that I'm wrong. There's going to be study after study after study, because all of these BS studies that have come out lately is to screw your mind. Okay? I've seen scholars write up stuff that really is degrading because it causes hate between settlers, and indigenous peoples. And then they write about stuff. They don't care what they write about as long as they get a paycheck, and they don't care about the consequences of what they're writing. So when are we going to start getting back to basics and common sense? Everybody is equal. Everybody has equal rights. Everybody has the right to live the way they wish, including trans people, including gays and lesbians. And we need to all get over that. If that's not what you support, that's their business. But they don't have any rights either to impose themselves on the others. So one doesn't have the right to impose themselves any more than the others. So let's start trying to show respect. You want respect, you show respect. So right now we have a rogue government, rogue scholars, rogue lawyers, rogue judges, rogue healthcare people. And then everything is being exposed at the international level in regards to the mRNA. And yet we're acting like it's all good here. Nothing to see here. Keep going. Go and get your shots. And I have to look like, is everybody on drugs? Where did sanity go to? Like, hello? I don't recognize my country, and I don't even recognize my neighbors. And everybody is so afraid of getting the finger pointed at that when you tell the truth, oh, now you're anti-Semitic. Excuse me? Do you realize that the Jewish people are being used right now? That you're being suckered into your little egotistic attitudes to fight against other people so that we lose all of our countries, our rights to our natural resources, and all of our rights globally, and then we're going to be stuck in our homes, under quarantine or under lockdown for environment. Does anybody look at the fact that the earth has a trajectory every so many 100,000 of years? That the pole is shifting naturally? You want to remove carbon? Well, might as well kill off the whole planet. Everybody's made of carbon on this planet. We need CO2. The trees need that to grow, and the plants and everything else. So who's working at that level in the environment to try and piss off the farmers and make sure we have no more food left? But hey, you can go and eat bugs. When are we going to wake up? It's insane. It's insane. Yeah, carbon is essential for life. Absolutely. So it's up to the Canadian citizens, and this is what the CPU is about taking our rights back legally. It's the only legal solution on the planet. And you've been hearing about it with every video that we've showed you in regards to this court case. And if you've listened, it gives you every debate has been had in regards to the rights of the people to self-determine. The only difference is they don't mention we have the right to self-determine as many times as we want. It doesn't say it's only once. And it doesn't say that our government has complete power over us. It just says we need a government. We pick and choose. Canadians have never had that right. And it further states that independent countries who were given independence but still controlled, as long as our constitution has the UK in there, our constitution belongs to the UK. We were never decolonized properly, and we have no business having Charles as our king. As long as Charles is there, we don't get our rights. So we're going to be making a proposal to all of you soon. Get ready for it. Because there needs to be an intervention by the Canadian citizens and the Indigenous peoples of this country to save this country, to save our natural resources, to make our natural resources work for us. And we have the right just like the Palestinians, to take back all of their natural resources. Okay? We control that. Somebody just mentioned weather modification through geoengineering. Yeah, and we can stop all that, but we cannot stop it until we take our rights. That's what the CPU is about. You're gonna, if you can understand what happened at the international level right now, you'll understand what the CPU is for, because it's exactly what we're for. And we've said exactly the same thing for years, where nobody here in Canada wanted to listen. Well, you better listen now, because we're all going to be forking out all of our natural resources and everything we do to pay restitution for what our governments have done, what we've allowed them to do. Just screaming freedom doesn't give you freedom, and freedom costs. Information costs. Education costs. It costs time and energy. That's the number one. Time and energy and devotion by every single one of us. So we have a very small window to make sure that our countries do not go to war. But we need to stand up in this country and all of the other countries as well. We need to stand up, because if the people rule at the end of the day, we can make sure there's no more wars, no more hunger, no more poor people. There's no reason for anybody to be homeless in Canada. There's no reason for seniors to go hungry because they don't have enough, while we send billions of dollars to another country for their pension funds. Does that make sense to you? Doesn't make sense to me. Now, the military has a job to do, and it must support the people, not wars. So I'm going to re-show you another video that I've been passing around, and I'm going to replay it here. This happened in 2010, and in conjunction with the Occupy movement. What happened with the Occupy movement? The government's put in infiltrators as the head of the leaders. What did they do with the yellow vest in France? They placed in people at the head of the yellow vest who were actually sent to the United States to learn about how to do open government in France for Macron. When I heard that, I said, what the hell are you? You're telling me that you guys, the head of the yellow vests, many of you were sent to the United States for open government under globalization, for one world government, and you're the leaders of the yellow vests? Well, don't ask yourself why I never went anywhere. They infiltrate everything they touch. Israel, the AIDL has infiltrated everything possible. They even boasted about it. I've got the thing from their website boasting that they infiltrated over 100 governments worldwide. The WEF is actually part of that. So what Freeland is doing there, and Trudeau and those little WEF puppets changing our policies, are actually double agents, and they should be thrown in jail for policy terrorism, because the policies they brought in is terrorizing Canadians and Indigenous nations across Canada and now worldwide through the WEF and their hands in to the G20. And it's actually 67 countries. But the other countries don't support that. So we got to be on their side. And we have to convince these countries that, are getting pissed off at the West, our country added to that, to say, hey, we don't support a government that's trying to throw us into a war or trying to cause chaos worldwide or bring us into a one world government. Instill digital ID. They started digital ID in the UK there. And my response was, oh, thank God it's not here first. At least now the people in the UK will have to fight it. And at least we can support them with their battle as well. But at least that's not one more issue we need to deal with right now. So it's all about timing. This is perfect timing. We've been justified in everything that has transferred at the UN in regards to Israel and Palestine. The international laws matter in our countries. Our governments cannot do this to the people in our countries any more than Israel could do it to the Palestinians, even though they were in charge of the Palestinians. So yes, our international law rights count. And the only ones who can jail right now are politicians until we have our rights and we instill that too, is the international level. So, are you going to take your freedom or your poison? Doing nothing is your point. You're taking your poison. Take your freedom. You sign our Citizens Convention of Consent. Become a member of the CPU and help us go door to door to talk to the people in your communities, because you are responsible in your own community to go to your mayors and stop the insanity there. We can't stop it everywhere. We need the people to actually do this, to stop what's coming in, what they're trying to enforce. And then, if the United States, the UK, and the globalists don't get what they want, they're going to throw a tantrum and threaten somebody with nuclear war. If we don't abide by them, people, we're going to be dead one way or another at their hands. I'd rather take my chances on talking to these people and seeing, they too, everybody in our government is a shareholder, co-owner of the Crown of Canada. Why are they doing this to us? They've got no business doing that. How do they think they're going to protect their children and their children? They're going to leave a really bad legacy. If people think that Brian Mulroney was a saint, he's the one that had while he was in power, the 2 referendums he was supposed to have was supposed to include if we were going to keep Charles or not, if the Canadian citizens approved of our Constitution to begin with, of our methodology within our governance. There's nothing wrong with the way the government is set up. What's wrong is the politicians that are crooked behind it. We don't need to really change our Constitution other than removing the corruption within it. Provinces could still be managing the provinces. However, their constitutions need to be burnt, because we have rights right across every province. The Indigenous peoples have rights coast to coast. Same with us, coast to coast. There's no business that any of the provinces should have any other rights. No provinces own the natural resources in those provinces. They belong to every single Canadian citizen and Indigenous persons in Canada. Whether you live in Nova Scotia or in BC, it don't matter. It belongs to the country. It belongs to the people. So, but hey, don't listen to CPU. They're crazy. I think we're the only ones who are right. And the international proves that we're right. People who understand international law and how the countries are supposed to behave agree with us. The only ones that don't agree with us are the ones lying to you to maintain the status quo, to keep Charles sitting in our position, and to say, hey, we're a monarchy. Whether you're a monarchy or republic, same same BS. No difference. Why? Because of representative democracy. We give away our rights for 4 years. All we have the right to do, really, is to vote for our next dictators. Are you okay with this? Are you okay that we're paying through the nose like slaves when we could be getting dividends instead of taxation? Wow, what a novel idea, right? If everybody ruled their own country, if everybody had the right to, have referendums on everything the government does before it does it, not, it's too late, they passed an unconstitutional law that now we have to fight tooth and nail for, and nobody has the money to fight them, but they take our money to fight us. Do you see anything wrong with this picture? I mean, when they give you a little check of $500, oh, look how good the government is. We're going to give you more credits. $200 per family, whatever. Oh, look at that. I could go shopping. I got extra money. It's your money. Stop thinking that the government is helping you. It's helping itself to your future and keeping you so poor or so tight, or, you know, trying to make ends meet. Because if you become too smart, you might know all this stuff and say, hey, where's the common sense? I got to show you this video, this young man. What happened to him since 14 years ago? I don't know. But it works for today. And the military needs to understand this. And the military needs to stop saying okay to the government, because the government hires private military to rule over them, and they get 50 times the salary they do. Yet it's their lives that are on the line, not the private guys getting 1,000 minimum. Well, 11 years ago, he thought $1,000 a day, as opposed to a regular little military guy that has a hard time making ends meet. But it's the military guy who's out there risking his life or her life. We need to protect our people, our military. Once the people are in power, we'd have no reasons for war, because all the migrants that are here could stay in their own countries, and we can help them get their natural resources out, make it work for them, give them Africa, one of the richest countries, the ones most stuck in apartheid, the ones who are hungry the most, have the richest country on the planet. What's wrong with this picture? They should be able to prosper and be happy and not have to worry about what another country is doing, as long as we're not sending bombs, threatening everybody like the bullies that we have been living with for eons. This is history in the making. We could make history. Finally, peace on earth is by having people who do not agree with war, who do not want war, and do not have rogue governments, and who actually participate. Would it be a lot of work for us? No. Do we overthrow our government? We don't need to overthrow our government. They need to start working for us. And they need to start knowing that we're watching. But things have to change. They can't just pass any laws that they want, especially when they have not a clue about human rights and they're trying to pass laws. Did David Lametti understand the law when he came out with the emergency measures? Hell no. Does this other one, Arif, know? Passing C-63? No, he doesn't. I am not a lawyer, but I'm not stupid. And I thank God I'm not a lawyer, because I'd be just as crazy as they are. And brainwashed that, oh, rights don't matter. They can step all over you anyways. You're just a subject of the government. We are the government. So, anyways, 9:35, people. I think I just hit the totem pole there with, you know. But I think about these Palestinian people. Are we going to wait till we're in their shoes before they say, oh, we should have listened to the CPU? Well, too late. The building where the CPU was is gone. Good luck with that one. Who knows? We don't know what the future holds. All we know is how the future can be if we all get involved and you start listening to the truth, to common sense, and to stop being worried about who's going to be pointing the finger at you. Who cares? If we don't do something right now, we're not going to last at all. Either way, we only have one choice, and that's to stand up. We're screwed one way or another. Might as well go out fighting legally with our rights. Talking to everybody we can. That's legal because everybody has the right to exercise their there are rights to civil and there are civil and political rights. We have those rights here in Canada right now. Okay? And we're going to make sure we have a document we're going to be sending out. And if the government and the lawyers and everybody doesn't listen this time, we'll have given them everything under the sun. Again, they choose to do nothing. They'll have to suffer the consequences because nobody in our government, all the way down from Prime Minister Trudeau to all of the premiers, to all of the legislatures, to all of the city councilors, mayors, police, anybody that's got a superior position to us, doctors, public health officials, have zero immunity. And Mr. Chrétien signed it in double in 2001 under the Statutes of Rome. Canada went way ahead of all the other countries to what? To show that it was so good that there'd be no chance that anybody ever take them to court and they will never have to suffer losing their immunity because nobody's going to dare because they kiss ass to the United States and the UK and everybody else. And then we're the ones that are advancing globalization with the first country to accept the World Trade Organization to allow the corporations to rule. Canada, number one. Who created the offshore accounts? But a Canadian lawyer and our Prime Minister, Paul Martin. The offshore accounts. For who? The elite. Aren't Canadians really nice? You know those that sun dimming, geoengineering sun dimming that they're doing in the US to every time that they would say, oh, we're going to have an increase in COVID cases. Check the sky. That was sun dimming. The whole sky was white. Totally white. When they do that, I can't breathe. I cough and cough. I've got bronchial asthma and COPD. 2 different coughs, 2 different times. I'm not crazy. It all depends on the weather. What's going on? What are they shooting at us this time? If the people were in power, life would be a lot better. It can't be worse than this or what it's going to be. Because it will get worse than this if we don't intervene. So don't leave it up to the farmers in Quebec, okay, to rise by themselves. It's got to be done across Canada. And even if the farmers rise and they don't sign their Convention of Consent, we'll be right back there the next year. Without the Conventions of Consent signed, and your support of the CPU, they're not going to be afraid of anybody. They're not. They need to know we mean business. We should be the official shareholders, co-owners of the Crown of Canada, seen legally, recognized legally in our Constitution, instead of Charles. And to have the prerogative powers as the head of states and take that away from the Canadian government, the Liberal government. It's not Justin Trudeau, it's the whole of the Liberal government. Conservatives just as well. None of the political parties right now, no matter how great they sound, have ever given us our rights, because Brian Mulroney, as a Conservative, was supposed to hold 2 referendums, one for the Indigenous nations, one for the Canadian citizens, and give us our rights. But in the referendums he tried to have, he never came out with it, with the true right that we have. It was all bullshit. Okay? All bullshit. And if you look at Brian Mulroney, he worked in the history. If you go to the idu.org, in the old history that they had, they changed the website because Brian Mulroney was named as working for the CFR 1983 for George Bush Sr. My lights just turned off. George Bush Sr. And he helped Merkel and everybody create the European Union in order for them to take over and control the European Union. Okay. So Brian Mulroney was then made our prime minister, sent by the courtesy of the George Bush family. Okay. All of them. Look at the history of everybody who's ever gone down to the United States, from the Conservatives and the Liberals, and the NDP will never make it. There's only 2 parties worldwide they're coming out with. It's the Liberals and the Conservatives, and what they call the Democrats and Republicans. Same thing. Okay? The Democrats are the same as Liberals, and the Republicans are the same as the Conservatives. And they're going to be in control worldwide. And who's at the head of this? Stephen Harper. And when you look at what's transpiring under CBC, when CBC starts knocking down the Liberal government is in charge of CBC. Why would it allow it to trash them? That's because the next party in is to be the Conservatives. So they need to sound really good to make it look like everybody voted for the Conservatives. Even if nobody would vote for them, they have to sound really good, because then everybody's going to assume, well, I guess everybody voted for them, they won. If you think that your vote counts, our vote hasn't counted for years, decades. Remember that. And why do I say that? Municipal elections or provincial elections here in Ontario, I don't know how many phone calls I got from people who were working at the during election day, and they were made to stop counting the ballots, and they already decided who the winner was when there was no determination of that at all ahead of time. Do I trust anything anymore? I asked them to write affidavits to that effect. They're all too scared. People will report, but they're too scared to stand up. So as long as Canadians are too afraid to stand up to common sense and reality, we might as well hope that another country saves our ass. Because obviously Canadian citizens don't have the guts to do it. Just as much as hypocrites as good talkers, but can't register common sense on how we can do it legally where the government cannot touch us. And that's to make sure the international knows. And that's what the CPU is about. So I'm just going to go ahead and do that thing here. Local video. Just one sec. Okay. And now I'm going to play you that video. I want you to listen to his words. And then I think we're going to call it a night. Because I need to go and bring my pressure down a little bit. Okay.
In a snowstorm in 2010, a young soldier named Mike Preisner, speaking without notes, became a legend with a spontaneous speech which identified the gulf between the real America and the America of the military media industrial complex. Every word he said echoes louder than ever today.
Susan Brothers, thanks everyone for being here. We're from the organization March Forward, and we are here to say to all those serving in the Army and the Marines and the Air Force and the Navy that you have the absolute right to refuse to take part in these criminal wars, and that's a right that all of you should exercise. You have no reason to go put your life on the line and kill and die for profit. We've been to Iraq, we've been to Afghanistan, and we know what these wars are really about. And we joined the military for many reasons. Because we need a college education, because we need a job, because we need health care. And then we joined the military, and they tell us that our enemies are poor people in caves in Afghanistan, or poor people in the deserts of Iraq. But we've been to those countries, and we know that our enemies are not other poor people abroad. Our enemies are the people that laid us off from our jobs, that denied us health care, that make it impossible to get an education. Our enemies are not in the poorest countries on the planet, but right here in the richest one. Now these wars, the occupations of Iraq and Afghanistan alone, are costing over $700 million every single day. This is a crime. Every single day, while so many of us are hurting. Well, I think all of us here, and the vast majority of people in this country, would agree that we can spend $700 million a day better than bombing people that we have no reason to bomb. We can spend $700 million a day rebuilding those countries we've destroyed. We can spend $700 million a day caring for the veterans we get home when they get home. And then we can spend $700 million a day giving every single person health care, a college education, a job, and a livelihood, and a home. That's what we need to be spending our money on. But this government is not going to do that. They're not going to use the money in that way. They're not going to end the wars. And they're not going to do it because it's not our government. It's their government. It's the government of the rich. It's the government of Wall Street, of the oil giants, of the defense contractors. It's their government, and the only language that they understand is shutting down business as usual. And that's what we're doing here today, and we're going to continue to do until these wars are over. Well, it's crystal clear now that these wars are going to continue and expand and go into other countries. That is the trend. That is what we know, that there is perpetual war, and it's only going to stop if the people stand up and stop it. And that's what we're going to do, sisters and brothers. And a lot of people ask me, what do we do? Because we all know things are bad. We all see the atrocities on TV. We read about it. We experience it. People always ask, what do I do? Because we always want to know what to do. Do we vote? Do we support a politician? Do we join an organization? What do we do? Well, I'll tell you what we do. It's simple. We fight. We fight and we fight and we fight, and we shut down our workplaces. We shut down our schools. We shut down the streets. We shut down business as usual, and we fight until we force the people in there to do what the people out here want, because that's how we're going to get around, and we're going to fight until there's not one more bomb drop, not one more bullet fired, not one more soldier coming home in a wheelchair, not one more family slaughtered, not one more day of U.S. imperialism. So let's fight to make that happen. We can do it today, and then the days ahead, we have to fight to end these wars and create a better world, sisters and brothers. So join us in that fight. Thanks.
Okay. There we go. So anyways, I love his speech. It's too bad that nothing has transcribed from it. Let's make sure that speech is worthwhile. And the thing too is that we need to realize that a lot of times, in the past for Occupy, They were placing people who could speak as good as he could as controlled opposition. And but the thing is every word that he said is true. Okay, very true. So when are we going to stand up and make sure that our country is safe, that our politicians listen to us? The CPU is not about taking down the government. It's about taking our rights. Okay. And the thing is right now in Canada, our rights are not being recognized. Well, if we can yell loud enough and be out there enough at the international level, which is what we've been working on now, while we're doing that, we need the Canadian citizens who are listening to us to step it up and to help us get door to door and to speak to everybody, because we've been shadow banned everywhere. And, because why? We've been telling the truth all along. And eventually people will realize this. And right now, the international level is proving me right every day. And that's why I want to re-show it to you. And people need to start reading the materials. You want to know what the CPU is about? Go to the cpu.ca. The power shifters are the people who sign our conventions of consent. The convention of consent is free. Be a political game changer. Help us change the system for the better. And to make sure that it's not the political parties that rule over us, that it's the people, so that our kids could have a future, that people stop being sick for nothing. Because the one thing that I learned, coming from a pharmaceutical research background, as a pharmaceutical researcher, until I went to research the law, then the history, 15 years. I've had this 15 years, February 28th, that I've been here on Six Nations. And I haven't given up yet, and I'm not about to. But eventually, someday, we may have to, if Canadians don't realize what they have, the power that they have, the power that you all have. We've got no choice. We can't allow these countries to create a war in order to control us, because that's what they do. Every time they want to change how the world works, they create a war. World War I was to remove the League of Nations. World War II, okay, again, finalizing that to create the United Nations. Now they want a one world government. They need to destroy the United Nations. And they'll put out lies. Read the documents before you say the UN is no good. I used to say the UN was no good. But not all levels. The ones who are fighting for our rights, you saw them. If you go and see how many countries have voted to stop the war in Palestine, you'll notice. Open your eyes. Stop looking at everything that is being passed around on your cell phones. Instagram, all of these things. Yeah, it's good to know what's going on, but you need to know what's going on at the moment that is being done behind your backs while everybody's playing on their damn phones. I don't need to know everything that's going on. I just need to know one thing: how to save our country, who I need, and how it can be done legally without people getting arrested. It's about knowing our rights and letting our government know that we know our rights, and the justices that we're watching them. They need to do their jobs properly and start reading the Syracuse Principles and the Johannesburg Principles and make sure that they're not overriding their power over us when they create laws, or the judges when they have a case in front of them. Justice Mosley finally did. Now we've got another idiot in New Brunswick. I thought it was from Quebec because he had a French name. Saying, we need to revamp the emergency measures to make it work in their favor. Well, guess what? There's a really high bar before you can use those emergency measures at the international level. There are rights that you can never derogate from, even in a pandemic or war. That's what's in those documents. That's what I've been passing around. That's what everybody's been ignoring. That's what everybody's not reading. As long as you know in your heart your power and your rights, even though they trample all over you or they try to, at least in your heart, you know you have tried and you did everything in your power to try and protect yourself against corruption. Know it for yourself. Know it for your children. And eventually, maybe it'll come in handy. If I'd have stopped 5 years ago, 2 years ago, what would I be thinking today, now that I see what Israel has done and how they lost all of the support that they thought they had? The best part of the whole week of the liberations by all the countries was the Arab states, who let down Netanyahu. He thought that they would have supported him. They nailed him to the wall. They literally nailed him to the wall. At some point, common sense has to give in. Bullies need to be destroyed. And bullies who risk their own people's lives need to be jailed forever. Okay, and when I talk about destroyed, I'm not talking about destroying. I'm talking about their power needs to be destroyed. And then they need to be put in jail. Because I worry as much about the Jewish people and the Palestinians. Because everybody's being used against one another. Our children are being attacked on all sides. The transhumanism they want to bring in, they're using trans people to be a threat to our children and to our way of life. But yet the trans people are so confused because they feel a certain way. I've met many of them, and I could swear some are more female than me. And I feel their pain. But not all of them are like that. Some of them, it's just because they've been brainwashed. So we got to make sure that they are really, really needing something. But we can all work together and not against each other to create a hate that has been brought about the ones at the top, to make sure that we are used against one another. We all need to come together. All need to come together. We are, first and foremost, human beings. That bullshit race thing. I mean, I've seen races, more racist than they claim the whites are. They're more racist themselves, but it's all culminated from hate, from being ostracized. So if you look at the real issues, we should not have those issues today. And it's nobody's fault what happened 500 years ago. We need to be together and understand each other and to help each prosper the proper way. What is so hard to understand about that? I'm not a religious person, but I have things that I would never, ever, ever do, no matter what. Because you need to try and understand both sides and not just be judgmental. I become judgmental when I'm pushed in a corner. And I understand that. But I try to fix that. So as long as we keep working on ourselves and working to help everybody else the proper way, then society might not be so bad after all. But we've created a society of many dictators that, oh, it's my way or no way. And, well, I'm not going to do anything because what's in it for me then? A bunch of little whiners? Is that what we've become? Oh, well, I'm not going to touch that. There's not something in it for me. So you're selfish? You don't care about what's happening to others as long as it doesn't touch you. We need to all look in the mirror here. We are the boots on the ground. We are the boots on the ground. We are the ones we've been waiting for. How many times have you heard that? Has it stuck yet? Nobody's coming to save us. Because every time somebody waited for a savior to come, it never really happened. Everybody's waiting. And then they say, well, I guess God had a plan for us. So when something terrible happens and a child says, why did God let that happen? Well, God has a better plan. The children, I created a hospital project for children who had cancer, who were being tossed out of the hospitals to be sent home to die, for their parents to take care of them while they died, for their parents to look at them every day and know that they couldn't do anything to help them when there was something that we could have helped them with. But our Canadian government refuses. Why? Because there's too much money in healthcare. Disease is good for the economy. That's what I learned from this Canadian government. Disease helps hire people. Disease helps hospitals make money. Disease helps everybody else make money, except for the dying. I stopped working on that project. Now, if you're a member, please go to our community. I've posted in there because it was better than private and better than for profit. I mean, for profit or public. Because it gave back to itself to expand. And these were government funds that would have had to pay for that. And then it goes back and then the hospital gives back to each of the community and all of the employees. Somebody washing the floor is as important as a doctor creating an operation. As important. Because if those floors are clean, no operation is going to work if there's too many germs. So the doctor cannot be without the floor cleaner. They are both worth the same, at least in my book. And you'll read that in my book in regards to the hospital, what I put together. But everything has to work for everybody. And everybody can still prosper individually on top of that. So why don't you go and find out what the CPU is about? Read, think. Don't ask somebody else's other opinion that doesn't know nothing about us, that assumes everything without reading what we're about, and at least trying to understand it. So this is what I'm asking of everybody now. This is do or die. Because the way that we're going, who knows what's going to happen? If we could have stopped this before 3 years ago, things would be different. If we could have put the people in power, this would have never happened, what we're seeing today. I guess I didn't work hard enough. I didn't yell hard enough. I didn't know that the courts I assumed that the courts and the justices would be honest because they have to follow the rule of law. The law is the law. This is what the law says. This is what I'm reading that the law is about. Here's my proof. Here's the precedents that prove that I'm right. We don't recognize that in Canada. Why the hell are you a lawyer? Why the hell are you even teaching it? Why the hell are you not fighting for the people? We assume lawyers are there and they're going to help us. We assume judges are there and they're going to help us. They've got their own lives. They've got their own issues. They don't have time. A lot of them don't even have time. A lot of them don't even know what's going on. Because everybody is in their little square, doing their own little thing, and not seeing the bigger picture. We see it, and we hope you do too. So there is a light at the end of the rainbow. And even though I seem frustrated tonight, I'm frustrated with Canadians, yes. I'm frustrated with even the Indigenous peoples, because nobody wants to listen. Nobody wants to try to really understand. They want me to say it in 5 words. Can't. There's too much. We have a book that you can have access to. I mean, our volume 1, which explains the CPU. We have a crash course about the CPU. You can check our videos. But that responsibility is in your hands. I can't do put an Elon Musk chip in your head and hope to hell that you all get the chip in your head so that you finally understand what I'm talking about. Okay? And I don't agree with Elon Musk chips in your head, okay? You can shove that up as yin-yang. Think about what you're putting in your body. So anyways, we have a light at the end of the rainbow. I mean, a pot of gold at the end of the rainbow if you want to take it, and a light at the end of the tunnel, okay? So there is a light. That's why I've been showing you these things. But we need everybody to get involved. Otherwise, it's going to be hard, and we might not succeed. And God forbid that we don't succeed. We need to succeed, and we can. And we can make sure the wars don't start. Okay? Nobody really wants wars. Only governments. Only those making money off of wars want wars. Let's stop them before they start. Let's stop this one in Palestine. Give them the right information so that they will always have final decision-making authority over their politicians and government, so that they will never be in the situation we all are worldwide today. CPU all the way. So I'll be back tomorrow morning at 10 a.m. for a short live, and again in French at 11 a.m. for the French people. But for tonight, I'm leaving you with this to contemplate, and more discussions tomorrow. Good night. Love you all. Bye-bye.
Attention, Canadians. Feel disconnected from our current political system? Join the power shift to freedom movement by the Canadian People's Union and be part of a bold vision for Canada's future. It's time to shift the political power to its rightful owners, the Canadian citizens and Indigenous peoples of Canada. Dive into our history, understand the need for change, and embark on the quest for true democracy. Are you concerned about our nation's commitment to human rights and self-governance? The power shift to freedom aligns with vital treaties and international laws, enabling us to claim our rightful place as collective head of state. We advocate replacing our partocracy system with a true democracy to ensure your voice counts more than party interests. When our national collective civil and political rights are respected, your influence on policies will be direct and impactful. Join us on this noble struggle to make every Canadian and Indigenous peoples a meaningful participant in our future. People 15 years old and over can sign the Convention of Consent and unite for our rights in the Constitution. Ready to be part of this transformative movement? Visit thecpu.ca for more details. Embrace the change and shape our future.